Okay, we're live.
Okay, great. Well, good evening, everyone. Thank you. I appreciate you joining us tonight for this meeting. Before we get into everything, I just wanted to say that I have completed the roll call, and we do indeed have a quorum present for our commission meeting. Before we get into the minutes, there is some business to take care of because we are pleased to welcome our new chair, Judge Brian D. Leonardo, from the Circuit Court for Carroll County. And as I stated in the email that I sent out to you all yesterday, we are very happy and fortunate, I think, to have Judge D. Leonardo back with us. He was a member of the commission for, I think, 4 or 5 years as the State's Attorneys Association representative before being appointed to the bench in Carroll County. So welcome, Judge D. Leonardo, and we're very happy to have you.
Well, it is nice to be back and see so many of the familiar faces. Very excited. I said when I left the committee to those that were here that really great people to work with on this. It's very substantive. Very often being on a lot of these commissions, sometimes you don't feel like you're really accomplishing. And one of the things I was very happy about being back is the work that's done in this committee, as well as the people on this committee. So yes, very nice to be back. With that, given that we have a quorum, I guess we will start into the business, which is first matter is approval of the minutes from May 10th, 2022. So is there a motion?
I would move to approve the minutes.
Okay, is there a second?
Second.
All right, having said that, any discussion on the minutes? Anyone opposed to adoption of the minutes from May 10th, 2022? Okay, seeing no objection, the minutes will be approved. So with that, great to see you again, Judge Avery. I will refer it over to you for the guidelines subcommittee report.
Welcome back, Judge D.
Judge Avery, may I
Leonardo.
interrupt you for just one second before we get started? I did, and this is my fault, I apologize. I also just wanted to recognize 2 other commissioners that are with us. We do have a new state public defender, Ms. Natasha Dartig. Am I pronouncing that right, Mr. Zaremba?
Dartig.
Dartig. Okay, thank you. I apologize that. So she is the new state public defender effective July 1 and replaced Paul DeWolf, who everyone knows retired. And so, but we are very fortunate because Mr. Zaremba will remain in his capacity as the representative of the public defender's office. So I'm very happy to have that continuity and certainly to have the expertise of Mr. Zaremba to continue with the commission. I also just wanted to briefly recognize that we have a new representative from the Attorney General's office for today's meeting. I think she's just standing in for today because Casey Murphy is just wasn't able to attend today, but we're pleased to welcome Katie Dorian as the representative on behalf of Attorney General Frosch. So welcome, Katie.
Thank you. Hi, everyone.
All right, Judge Avery, sorry to interrupt her.
No worries. Okay. All right. The guidelines subcommittee did meet on June 30th of this past month. We have 3 action items, including recommendations from the guidelines subcommittee. And David, I will turn it over to you to describe those action items.
Thank you, Judge Avery. So we will start with the agenda item. The first one in the subcommittee report is the proposed classification of new and revised offenses from the 2022 session. And I will review this particular item, and then Catherine will be reviewing the second subcommittee item, and Sarah will be reviewing the last one. So most of you are familiar with this portion of the meeting. This is something that we do on an annual basis, and that is to consider how all new or amended offenses that were passed during the most recent legislative session need to be classified within the sentencing guidelines. And so I just want to give a quick review of the process that the commission takes in order to do that. It's the task of classifying new or revised criminal offenses is something that's designated to the group's guidelines subcommittee. And then those classifications will be presented as they are this evening to this full commission for your review. And in preparation for that task, the staff will review all legislation from the last legislative session and prepare a memorandum that you have seen was sent to you for this evening that identifies the new or amended offenses that carry a maximum penalty of greater than 1 year of incarceration. And we focus on those with greater than 1 year of incarceration because by rule, the Sentencing Commission does not require classification of offenses that carry a penalty of 1 year or less. Rather, those offenses are automatically assigned a seriousness category 7, which is the least stringent seriousness category option. So I refer you to the memorandum that's labeled Proposed Classifications of New or Revised Offenses 2022 session. This is a 17-page document that's generally divided into 3 sections. The first is new offenses with action recommended. The second section is changes to existing offenses with action recommended. And then the third is new offenses with no recommended action and changes to existing offenses with no recommended action. So for your reference, we also provided a supporting document that was labeled Combined File of Legislation with New or Revised Offenses 2022. Now, this is a PDF that combines all the legislation that is reviewed in the new or revised offense memo, and the bills appear in the order that they are listed in the proposed classification memo. And based on previously established protocol, the subcommittee offers seriousness category recommendations by examining currently classified offenses that are comparable based on the following. The first is type of offense, whether it's a person, drug, or property offense. Second, statutory maximum penalty. Third, the misdemeanor felony classification. And finally, when possible, the nature of the offense itself. So for each new or amended offense, the memorandum will present comparables that are either at the bottom of each page or possibly on the subsequent page if there's spacing limitations. So with that introduction, I'd like to go ahead and get started, starting on page 1 of the proposed classification memo. The first new offense from 2022 comes from chapter 26, which is House Bill 837. This bill establishes that under criminal law article section 5-601.2 prohibits the cultivation of cannabis plants under certain circumstances and provides that this offense is subject to up to 3 years of imprisonment and or a fine of $5,000. House Bill 837 will take effect if in the November 2022 general election, Maryland voters approve a constitutional amendment legalizing cannabis use and possession by individuals 21 years of age or older. And that is House Bill 1. If the constitutional amendment is approved, then the new offenses established by criminal article 5-601.2 will take effect on July 1, 2023. The comparable offenses are listed on page 2 of the memorandum. And based on the statutory maximum penalty of 3 years and a review of the comparables, the subcommittee recommends classifying cannabis cultivation in violation of the requirements provided in 5-601.2, as a drug offense with a seriousness category of 5. The discussion around this was ultimately a unanimous recommendation of the subcommittee. The subcommittee noted that this new cultivation offense was more closely aligned with possession or distributing controlled non-marijuana paraphernalia, which is a category 5 offense, as opposed to a simple possession offenses, which are categorized as category 7 offenses. So that is the recommendation of the subcommittee to classify this first offense as a drug offense, seriousness category 5. So I will present that as the recommendation and open it up for comment and discussion.
So having obviously not been part of the discussion, is there any of the classifications of which there was disagreement among the subcommittee?
In this particular instance, there really wasn't. And for any of the offenses that we're going to discuss this evening, we had unanimous. There was definitely discussion and debate, but ultimately resulted in unanimous agreement. I believe I've stated correctly for all of the offenses, but I'm sure subcommittee members will chime in if I'm missing one or two. But I think in this instance, which I would say is pretty rare, that we did have unanimous agreement.
My recollection is the same, that with regard to the new offenses, that we did discuss all of the possibilities for classification and things like that, but ultimately we agreed as to the recommendation that's before you.
So is it easier, David, then to do all of them and then make one motion?
Well, so I think Judge Zeland, yes, for the first few that we're requesting action on, I think it is better to go through them on a one-by-one basis and just, we can, ask if there's any votes in opposition, and if there's none, we could probably get through them pretty quickly. But then when we get to roughly page 9, that we can kind of just take in bulk because none of those have recommended action.
Okay. All right, so you're looking for a motion then as to the first category? Okay.
Correct.
So does anyone wish to make a motion?
I think I can move to approve as the chair of the subcommittee, and I would move to approve all of them, but we should still go through each one individually.
Second.
Thank you.
All right, so I guess the motion then is to approve all of the recommended changes that are set forth in your materials, although David will still go through with an explanation. That's the motion, I think that's on the floor. Okay, anyone object to that? All right, seeing no objection, the motion carries. So David, if you could just explain, I guess, some of the changes in case
Sure.
there's any questions.
Okay, we can move on to page 3, and that will be continuing with chapters 18 and 19, which is House Bill 425 and Senate Bill 387. This legislation alters the definition of firearm to include an unfinished frame or receiver without a serial number. In other words, or what is referred to as a ghost gun, and create a new offense prohibiting a person from purchasing, receiving, selling, offering to sell, or transferring such an unfinished frame or receiver. The new law prohibits a person from possessing a firearm on or after a certain date unless it is required by federal law to be and has been imprinted with a serial number in compliance with certain federal laws and regulations. There are identified comparables at the bottom of page 4 of the memorandum. The subcommittee recommends classifying the 5-year misdemeanor for purchasing, receiving, or selling a ghost gun as a category 5 person offense. Further, the subcommittee recommends classifying the 2-year misdemeanor for possession of a firearm that has not been imprinted with a serial number as a category 6 person offense. With respect to the ghost gun 5-year misdemeanor, the subcommittee believe this offense should be categorized similarly to how a straw purchase offense is categorized. And that was the comparable that really the subcommittee focused on and utilized for the recommendation. And again, this was a unanimous recommendation of the subcommittee.
All right, any questions as to that? All right, seeing none, David.
Okay, great. We can move on now to page 5. On page 5, we are addressing chapter 642, which is Senate Bill 15. This Senate Bill 15 adds numerous new offenses to the election law article, 2 of which are subject to more than 1 year of imprisonment. So those are the ones we focused on here. First, the bill prohibits a person from willfully making a false, fraudulent, or misleading statement under oath in a campaign finance report and provides that this offense is punishable consistent with the crime of perjury, which is a misdemeanor subject up to 10 years of imprisonment. Second, the bill prohibits a person from submitting a campaign finance report on behalf of another person without that person's consent and provides that the offense is punishable consistent again with the crime of perjury. Senate Bill 15 also adds a new offense to the general provisions article prohibiting a person from willfully making a false, fraudulent, or misleading statement under oath in a statement filed by a person providing compensation to a lobbyist, and provides that this offense is punishable consistent again with the crime of perjury. So perjury here seemed to be the most appropriate comparable. Obviously, subcommittee correspondingly recommends classifying this offense as a property offense with a seriousness category of 4.
Okay, does any of the members have any questions? All right, seeing none. David?
Okay, great. Also just wanted to acknowledge, I saw that Judge Lewis just joined us. Thank you, Judge Lewis. We appreciate that. We are on to page 7. of the memorandum. This is where we start reviewing changes to existing offenses that warrant consideration of action by the Sentencing Commission. So page 7 deals with, again, this is an offense that comes from the cannabis legislation that we previously discussed, which is chapter 26, House Bill 837. The relevant section here that we're discussing of this particular bill establishes that under Criminal Law Article 5-607, a person who possesses with intent to distribute or manufactures cannabis in violation of 5-602B1 or 5-603B, respectively, is guilty of a misdemeanor and upon conviction is subject to imprisonment not exceeding 3 years or a fine not exceeding $5,000 or both. Additionally, the bill allows that for the adult sharing of personal use amount of cannabis and establishes that adult sharing of personal use amount of cannabis does not violate Criminal Article 5-602. Currently, the possession with intent to distribute or manufacture of cannabis is punished consistent with the distribution or manufacture of other non-narcotic controlled substances under 5-607 and has a penalty of maximum penalty of 5 years, which is opposed to 3 years for this altered offense. After House Bill 837 takes effect, possession with intent to distribute and manufacture cannabis will be punished differently from other non-narcotic controlled agent systems. So again, it would be 3 year maximum penalty as opposed to a 5 year maximum penalty. Again, just want to emphasize that House Bill 837 will only go into effect if in the November 2022 general election, voters approve a constitutional amendment legalizing cannabis use and possession by individuals 21 years of age or older. So if it is approved, these provisions will take effect January 1, 2023. So commission reviewing all this information and looking at comparables, the subcommittee classifying this offense as a drug offense, obviously with a seriousness category of 5. And that was the recommendation of the subcommittee. So I'll present that for any discussion.
Okay, doesn't appear, David, any commentary? So I think the rest of it you have is no recommended change.
Right. So for the rest of the document, there's no recommended action. And let me highlight why. There's no recommended action for these because for the offenses listed on pages 9 through 11, these are new offenses that have a maximum penalty of 1 year or less. So the commission has a longstanding policy that for those offenses with a penalty of 1 year or less, they are automatically assigned a seriousness category 7 unless the commission chooses to adopt a different serious category. The legislation that's noted on pages 12 through 17 all offer changes to existing offenses. However, the legislation offers no change to the criminal penalty structure and therefore no recommended action. There's no recommended action from the subcommittee. So again, I would just say I'm happy to review any of the specific offenses with this no designated action. But if not, I think we can conclude the report. We can go. But if anyone wants to go through any specific one, we certainly are able to do that.
I see Delegate Bartlett has her hand raised.
Oh, thank you, Sarah, for pointing that out.
Thanks. I have a quick question regarding the possession with intent to distribute section that we just went over. I'm sorry, I'm having trouble getting back to that. There we are. Did the guidelines subcommittee have any opposition, or was that a unanimous decision as well?
Delegate Bard, that was it was in a unanimous decision.
Okay, great, thanks.
Okay, well, we had a motion, and since it's, the motion was, unless there was any specific objections, all the recommended subcommittee classifications would go forward. And I think at this point, I'm not seeing any, so I think we can go ahead and say that those all have been approved. So I appreciate everyone's time in going through that. So that'll conclude the review of the new and amended offenses from the 2022 session. So we'll move ahead to the next section of the subcommittee agenda. And I'm going to turn this over to Catherine to present to the full commission. Thank you.
Thanks, Dave. So I'll now refer everyone to the memo labeled Proposed Revisions to the Instructions for Data Collection on 3-Judge Panel Reviews and Sentence Modifications. The Maryland State Commission on Criminal Sentencing Policy currently receives sentencing guidelines worksheets for 2 types of cases involving non-original sentencing events. 1, reconsiderations involving crimes of violence if an adjustment is made to the active sentence, that being the period of incarceration, and 2, 3-judge panel reviews if an adjustment is made to the active sentence. Multiple practitioners have contacted the MSCCSP with questions relating to the collection, reporting, and guidelines eligibility of certain non-original sentencing events. More specifically, practitioners have expressed confusion as to how to properly report the reconsideration, COVs only, and 3-judge review field on the sentencing guidelines worksheet, and have questioned the types of reconsideration scenarios that require a sentencing guidelines worksheet. In a review of sentencing guidelines worksheets submitted in fiscal years 2020 and 2021, staff identified a substantial number of worksheets involving original sentencing events that were misreported by practitioners in the Maryland Automated Guideline System, commonly referred to as MAGS, as 3-judge panel reviews. Based on data obtained from the Maryland Judiciary's Administrative Office of the Courts, 3-judge panel reviews involving a modification to the defendant's active sentence are rare. Given these findings and questions from practitioners, staff first presented 2 potential actions regarding the MSCCSP's current data collection protocol to the Guidelines Subcommittee for consideration at its April 25th, 2022 meeting. First, that we remove 3-judge panel reviews from the MSCCSP's data collection protocol. And second, to clarify the definition of the term reconsideration involving a crime of violence. With regards to potential action number 1, removing 3-judge panel reviews from the Commission's data collection protocol, during its April meeting, the subcommittee expressed a desire to continue collecting 3-judge panel reviews in some form, given that a 3-judge panel review constitutes a modification to an original sentence. With regards to potential action number 2, clarifying the definition of reconsideration involving a crime of violence, the subcommittee unanimously supported adding clarifying language to the Maryland Sentencing Guidelines Manual, Code of Maryland Regulations, MAGS, and the Sentencing Guidelines Worksheet where applicable to help bring further understanding as to the types of non-original sentencing scenarios involving crimes of violence that require a guidelines worksheet. While the subcommittee did not reach a consensus regarding specific language during the April meeting, there was agreement to revisit the discussion at its next meeting. The Guidelines Subcommittee then met again on June 30th, 2022, and ultimately agreed to recommend to the Commission 2 actions. 1, limit the collection of 3-judge panel reviews to those involving crimes of violence, and 2, adding the term modification to reconsideration and other clarifying language to the Guidelines Manual, COMAR, MAGS, and the Sentencing Guidelines Worksheet where applicable. The proposed amendments in their entirety are provided at the conclusion of this memo. Now, to provide some background history of the Commission's collection of reconsiderations and 3-judge panel reviews, House Bill 1143 created Criminal Procedure Article 6-209, B13 and 4, which provides that the Commission's annual report shall review reductions or increases in original sentences that have occurred because of reconsiderations of sentences imposed under 14-101 of the criminal law article, and categorize information on the number of reconsiderations of sentences by crimes as listed in 14-101A of the criminal law article and by judicial circuit. This law went into effect on October 1, 2002. While Criminal Procedure Article 6-209, B13 and 4 do not explicitly require that the Commission collect information for 3-judge panel reviews, it is the staff's understanding that the Commission made the decision to collect information on both reconsiderations and reviews, given that both can result in adjustments to original sentences. Further, only 3-judge panel reviews can result in an increase to an original sentence. It's unclear whether Criminal Procedure Article 6-209, B13 intended to include 3-judge panel reviews for this reason, but it lends another possibility that could help to explain the Commission's initial decision to include them in its data collection. Pages 2 and 3 of the memo list the present day instructions regarding 3-judge panel reviews and reconsiderations in the guidelines manual. Effective July 1 of 2019, reconsideration or 3-judge review became a separate and mandatory field on the sentencing guidelines worksheet and in MAGs. This change was made in light of analyses showing that worksheets for reconsiderations were often reported according to their original disposition type and not coded as reconsideration or review, therefore resulting in an undercount of reconsiderations and reviews in the sentencing guidelines data. In response to the reconsideration or 3-judge review field becoming mandatory in MAGs, the staff noticed an increase in cases being misreported, and practitioners have expressed confusion as to what option to select for this field. Misreporting is particularly an issue with original sentencing events being reported in MAGs as 3-judge panel reviews. In fiscal years 2020 and 2021, monthly data provided to the Commission from the AOC identified 0 sentencing events involving eligible 3-judge panel reviews. In contrast, when analyzing data submitted via MAGs, staff identified a total of 279 sentencing events that were marked by practitioners as 3-judge panel reviews. Staff reviewed each of these cases on Maryland Judiciary's case search, and only 5 of the 279 cases involved a 3-judge panel review. The remaining cases were original sentencing events. As noted above, the Commission is statutorily required to report annually on reconsiderations of sentences imposed under 14-101 of the criminal law article. In recent years, multiple practitioners have expressed confusion regarding the types of reconsideration scenarios that require a guidelines worksheet. The guidelines manual does not include an explicit definition of reconsideration, nor is the term reconsideration defined by Maryland rule or statute. In collecting sentencing guidelines worksheet, the Commission has taken a broad approach in an effort to capture eligible modifications to crimes of violence, generally instructing that a worksheet should be completed for any modification to the active sentence for a crime of violence, including those that result from Health General Article 8-507 orders. For this reason, practitioners and staff alike believe modification is a more universally understood term, and that clarifying the term reconsideration by adding modification would help bring further understanding as to the types of sentencing scenarios involving crimes of violence that require a guidelines worksheet. Additionally, during its April 25th meeting, the Guidelines Subcommittee recommended adding several drop-down options in the MAG system to further identify the type of modification involving a crime of violence. These drop-down options would include 1, pursuant to Maryland Rule 4-345, 2, a Health General Article 8-507 order, or 3, a 3-judge panel review. Given the lack of explicit statutory requirement, rarity of cases, and continued misreporting of 3-judge panel reviews, the Guidelines Subcommittee agreed with the staff's proposal to limit the collection of worksheets for 3-judge panel reviews to those involving crimes of violence. This change would provide consistency with the data collection protocol and reporting requirements for reconsideration/modifications. Staff also speculates that limiting the collection of 3-judge panel reviews to crimes of violence would help to reduce the amount of misreporting currently seen in MAGs, as the application could be reprogrammed to only enable the modification to crime of violence sentences field if the sentencing event involves a crime of violence as defined in criminal law article 14-101. Lastly, the Guidelines Subcommittee reviewed and agreed to recommend to the Commission proposed language that adds the term modification to reconsideration in the Guidelines Manual and COMAR and simplifies field headers and MAGs and on the Guidelines worksheet where applicable. Proposed revisions to the Guidelines Manual, COMAR, MAGs, and the Guidelines worksheet are detailed on pages 5 through 7 of the memo. With regards to MAGs, the Guidelines Subcommittee also agreed with the staff's proposal to add an additional field to the GLS overall sentence tab. This field would only become enabled if the sentencing event involved a crime of violence, as defined in criminal law article 14-101, and would ask, is this sentencing event the original sentencing event or a modification to a crime of violence sentence? That is, an adjustment was made to the active original sentence. The reconsideration COVs only and 3-judge review field would then be replaced with modification to crimes of violence sentences. If the user selects that the sentencing event is a modification to a crime of violence, the modification to crime of violence sentences field would become enabled, and the user would then select one of the following modifications from the drop-down menu. Pursuant to Maryland Rule 4-345, Health General Article 8-507 order, or 3-judge panel review. And that concludes my summary. I will now turn it over to Dr. Souley and the Commission for further discussion.
Thank you, Catherine. I appreciate that. I know everyone that was a lengthy review, and the subcommittee has now heard it for 2 meetings. I will not reiterate everything there. I just want to kind of get to the gist of this. The data collection for these reconsideration has proved to be incredibly time consuming for the staff. We spend, I'm almost embarrassed to admit how much an exorbitant amount of time trying to correct misreportings of either modifications or 3-judge panel reviews. And it's such a minor proportion of the overall sentencings that we have really put a lot of thought, and you could probably tell, into trying to find a way to simplify the reporting of these and to eliminate cases that are basically being erroneously reported as modifications. And so this is, I think, maybe our 3rd crack at here to try and change this. So I think this time this presents a reasonable solution. It's still, we are now at least, we're doing still above the bare minimum here that we are statutorily required to do. You know, we are statutorily required to report on reconsiderations. That's the term that's used in the statute, although reconsideration is not the universally necessarily understood term here, but that's what we're required to do for crimes of violence. The commission chose to add 3-judge panel reviews back in when this first came into effect 20 plus years ago. And Catherine explained why we think that probably was the decision back then. But what is happening is that we're now seeing cases that are being erroneously reported as 3-judge panel reviews that are clearly not 3-judge panel reviews. So I just kind of wanted to give that, I'll stop there. That was a lot of discussion and a pretty long memo to say that we are trying to come up with a way to clean up the data collection and reporting with these sentence modifications.
So if I could just jump in real quick, and hopefully we can just get to a vote on this, because really this is a very reasonable way to solve a problem. I think that clarifying the reconsideration language is going to eliminate a lot of the erroneous submissions, because reconsideration as a word doesn't really exist with regard to criminal law. And I think that may have caused confusion in and of itself. So with the clarification and the reasonable adjustments, I think we finally got to the right place. And of course we can continue to look at it. I mean, if there are still continuing erroneous submissions, then maybe we
Right.
missed the mark in some way, but we can always go back and reevaluate. So with that, I would just I would move for the commission to accept the recommendations put forth and described in the memo. Of course, if there's any discussion, any of the members of the guidelines subcommittee can field any questions.
Okay, well, we'll ask for a second and then we can have any discussion. So the motion to adopt the recommendation of the subcommittee on the 3-judge panel reviews.
Second.
Okay, so there's a second. So any discussion of any of the commission members? Okay, seeing no discussion, anyone opposed to the motion? No one indicating opposition, the motion carries.
Thank you.
Great, thank you. Okay, so for the last item on the subcommittee agenda, I am going to turn that over to Sarah Bowles to review the issue regarding the clarification of the definition of weapon presence. Sarah?
Thanks, Dave. I'll refer you to the memo entitled Clarifying the Definition of Weapon Presence. Staff have received multiple questions from practitioners regarding the definition of explosive as it pertains to the assignment of weapon presence points in Part C of the offense score. Specifically, practitioners have questioned whether the presence of items designed to start a fire would constitute an explosive. So for instance, if the defendant attempts to set fire to a person by using gasoline in a lighter, would that be considered an explosive for the purposes of applying 2 points for weapon presence? The current definition of weapon presence is provided on page 1 of the memo. Weapon presence is defined as the presence of an article or device which reasonably appears capable of causing injury, or the presence of an article that could result in conviction under Criminal Law Article 4-101. And for your reference, the full text of Criminal Law Article 4-101 is provided, starting on page 4 of the memo. The definition of weapon presence goes on to state that explosives are considered the same as firearms, which means that their presence is awarded 2 points. Weapons other than firearms are awarded 1 point and include incendiaries. Based on this definition, the presence of gasoline in a lighter to set fire to a person may be considered an incendiary, which would equate to 1 point for weapon presence. However, given that the manual does not further define explosive or incendiary or reference the specific scenario, the staff have been instructing practitioners that it's ultimately at the judge's discretion as to whether 1 or 2 points should be awarded. The Guidelines Subcommittee discussed this issue at its June 30th meeting, and given the uncertainty among practitioners, the subcommittee unanimously recommends that language be added to the manual in COMAR to clarify the definition of weapon presence, explosives, and incendiaries. These revisions are provided on pages 2 and 3 of the memo. The revised language would reference the definition of explosive material and incendiary material provided in Criminal Law Article 4-501. Criminal Law Article 4-501 also provides reference to the definition of explosive provided in Public Safety Article 11-101. And the full text of both of these statutes are provided on pages 5 and 6 of the memo. Providing a reference to this statute would provide clear guidance that items designed to start a fire, gasoline, and a lighter would constitute an incendiary or a weapon other than a firearm and be awarded 1 point for weapon presence. Providing this reference would also add to the list of weapons other than firearms, toxic materials, which are also defined in Criminal Law Article 4-501. And with that, I'll turn it over to Dr. Souley and the committee for discussion.
Thank you, Sarah. I appreciate that. Again, as Sarah noted, there was some discussion on this, and I can certainly, subcommittee members can weigh in, but this also was, as Sarah noted, a unanimous decision or recommendation of the subcommittee that we think will help bring some clarification and hopefully lead to consistency in scoring relative to the application of weapon points when scoring the offense score.
Okay, well, is there a motion?
I would so move.
All right, a second?
Second.
Okay, so there's a motion and a second to adopt the recommendation on the proposed language to clarify the definition of weapon presence. Any discussion on the motion? Okay, seeing none, is there any objection to the motion carrying as set forth? Seeing none, the motion carries. So Dr. Souley, Executive Director report.
Absolutely. Yeah, I appreciate it. I think it's your calming influence in your first meeting, you know.
Well, I'm glad to see everyone getting along as always.
I think it's being able to see him as opposed to the phone calls we used to get.
Okay, so I guess we can move along then, right, to the, sorry, it's more of me talking, but to the Executive Director report if we're ready. Is that okay? All right, so I have 4 items to review as part of my report. The first item I want to discuss is the Department of Legislative Services required report on racial biases at sentencing. At our commission meeting on May 10th, we reported that during the legislature's review of the commission's fiscal year 2023 budget, an analyst from the Department of Legislative Services recommended, and the budget committees ultimately agreed, that the commission develop a plan for studying the extent to which racial biases are present in sentences assigned throughout Maryland courts. At the May Commission meeting, the staff reviewed a proposed outline for the analysis. On June 30th, I distributed the detailed plan for the analysis based on that outline. And thank you. We requested feedback, and we did receive some feedback on that, and I appreciated that. We were able to revise the plan to include an analysis, to indicate that we will include an analysis of sentencing factors by race and ethnicity that would be disaggregated by judicial circuit. And we added judicial circuit as a measure after receiving a suggestion from Dr. Johnson, who indicated that it may be important to include a measure of the geographic location where the defendant was sentenced. And the staff agreed with that recommendation. And so we did include that in the plan. So this plan for analysis was submitted. We have submitted it. It is due to the legislature by this Friday, July 15th. And again, I do want to emphasize, this is a plan for analysis, right? This isn't the actual report. We were asked to submit a plan, and that's what this was. And then we included in that plan that we would anticipate that we would complete a report summarizing the results of the planned analyses 1 year later by July 15, 2023. And as those of you who have been with the commission know, we did start some of the review of these analyses. So we do plan to be continuing those, and likely we'll be presenting some of them at our next commission meeting in September. The second item I wanted to report was just to give an update on the status of the July 1 revisions to the sentencing matrices for drug and property offenses. As you all know, the sentencing matrices for drug and property offenses were updated effective July 1. And to account for the July 1 effective date, the Maryland Automated Guidelines System and the Guidelines Calculator tool were reprogrammed to account for revisions to the drug and property offense matrices. A guidelines e-news was distributed to all criminal justice practitioners in the state on June 1. We were highlighting what at the time were the pending revisions, and to provide information about how to account for those revisions in MAGS and the guidelines calculator tool. Then on June 30th, the staff distributed another reminder notification to indicate again that the pending revisions would take effect the next day on July 1. And the email provided links for the revised sentencing guidelines manual, the June 1 guidelines e-news, a training webinar that was led by Catherine Pembroke from our staff to review the revisions to the sentencing matrices, along with we included just a review of other recent and upcoming anticipated guidelines updates. And finally, we included a PDF of the revised drug and property matrices. So to date, the transition to the new matrices, I think, has gone really smoothly. And I think that's a credit to my staff who've just done a really good job of making sure we're getting the word out and making sure that it would be hard to say that you were surprised by these changes, I think, at this point. And just to make sure that we provided multiple training opportunities and webinars. And so I think, sent out emails, sent out a link to a video explaining the changes. So I think that that helped contribute to the smooth transition to the new matrices. And so in a few years, we will probably take a look back and see what effect these revisions had. Third item I want to report to is just kind of continuing up. As I mentioned, we completed multiple webinars in June, 4 webinars that focused on those July 1 updates to the sentencing matrices. Those sessions were held on June 1st, June 10th, June 13th, and the 29th. And we posted a YouTube video of the webinar on our website for a reference if anyone is still interested in learning more about those. Additionally, either myself or Catherine met with judges and court staff from multiple judicial circuits in May and June, including with Judge DeLeonardo's group in the 5th Judicial Circuit. And so, I think all of our notices and training videos and recent meetings really helped to contribute to a smooth transition with all these recent updates. Okay, the last item I want to report on is the Sentencing Commission is hiring. That's not something I say very often, mainly because I'm very lucky. I've had a lot of continuity in my staff, so not a lot of turnover on my staff. But This is actually a little bit different scenario. We don't have turnover, which I'm very happy about, but we have the opportunity to hire a new staff person. And that is the result of the General Assembly passing Senate Bill 763. And as you, most of you are aware, we've discussed Senate Bill 763 in these Sentencing Commission meetings. And this was a bill that is called the Maryland Criminal Justice Data Transparency Act. And there were two provisions of Senate Bill 763 that really impact the Sentencing Commission. The first is that the commission's annual report is now required to include a specific analysis and report regarding crimes of violence. And that is something that we will have to include in our, starting with our next annual report, which will be the one that it will be due in January of 2023. So just the next one that'll be coming up here in a few months. Second, the Sentencing Commission is required to add a data dashboard to our website. And that is something that we have to add in order to report on the additional sentencing details about crimes of violence. So we're taking the new information that we're reporting on in the annual report about crimes of violence and putting it in a data dashboard. And so the governor's supplemental budget included funding for the Sentencing Commission to complete this new crimes of violence report and the corresponding data dashboard. And the funding provides for the Sentencing Commission to hire one new full-time staff member. And we are in the process of getting that position posted. It's something that we're working with the University of Maryland Human Resources Department on. The position is currently, I guess, being created within the University of Maryland system. Position title will be a research assistant. Primarily, we're looking for someone to assist with collection of sentencing guidelines data, working with criminal justice partners to verify data, assisting with the creation and maintenance of the sentencing data dashboard that I mentioned, working with staff to develop and write the new section of the crimes in the annual report about crimes of violence, and also just compiling, maintaining, and distributing monthly and biannual jurisdiction-specific guidelines, worksheet completion, and submission reports. So that's something we're looking for having the new staff person to help us out with. So we're looking for someone that has experience in data spreadsheet management. That's something we're requiring, and preferably experience with statistical software packages such as Stata or SPSS or SAS. So once the position has been officially created, it's something that takes a little bit of time, but we're waiting on that. I was hoping I would have a posting, but I will have a posting here shortly. Once I have the official posting, I will certainly share it with all of you and ask if you know anyone that may be interested in such a position to please feel free to distribute that posting to them. But we are excited to have the opportunity to add to our staff. It'll be a welcome addition for sure. So that concludes my report. I'm happy to take any questions if there are any.
David, I'm just wondering, is this a temporary position or is it something that will be permanent?
No, thank you, Brian. I appreciate that. No, we're expecting it to be a permanent position for the Sentencing Commission.
All right, well, it doesn't appear there's any other questions. It looks like the next matter, the remaining meetings, we have September 13th, 2022 at 5:30 p.m. My understanding, David, that is going to be back in person. Is that correct?
That is correct. So that is the plan, everyone. So that'll be the big change. We would like to get together for the first time in a while in person since the start of the pandemic. So we have a room reserved at the Maryland Judicial Training Center. This commission hasn't actually met in the new building yet. It's been a while, so this will be our first time in the new facility at the judiciary. It is a nice, convenient location. It's easy to park at and get in and out of. So there definitely are some benefits on that. So that is our plan, that we would move forward with that. And then I think we can discuss at that time, what the plan might be for the December meeting, which is traditionally our combined meeting, a public comments hearing and a business followed by business meeting.
The good news is that September meeting, David said they're doing shrimp, lobster, and steak. Right?
That's right.
Got the dinner that's being provided? All right.
Yeah, I mean, now that we're flush with funds.
All right, great. Any old business?
Hmm.
Okay, seeing none. New business or its announcements? It appears none.
All
Well,
right.
that was a very expedited meeting.
That was great. Again, you got us off to a good start, Judge DeNar. We appreciate that.
Oh, I'm sure the debates will come. I'll say that.
Well, okay. Well, I appreciate it. Thank you, everyone. I guess, sorry, I shouldn't jump in on Judge DeNar. If we could call for a
Motion to adjourn?
motion to adjourn. Yeah.
All right, we got a motion. There's a second.
Second.
All right, anyone opposed?
Mhm.
No one is. Okay, well, wonderful. Well, again, great to see everybody again. I look forward to working with you and seeing you in person in September.
Absolutely. I hope everyone has a great rest of your summer. Enjoy. We'll see everyone in
Night
September.
all.
All right.
Thank you.
Good night.
Take care. Good night.